Motion be agreed to.
Mr Speaker.
Honourable David Parker.
Thank you, Mr Speaker. I agree with much of what the Minister said in his address on this bill. The Labour opposition supports this bill. It is a timely overhaul of the way in which legal aid is provided and will have particular impact in respect of criminal legal aid. The inquiry by Dame Margaret Baisley did find some poor practice. And when we were considering submissions, we heard from retired Judge, High Court Justice Hanson, who used to be the Executive Judge for the South Island, a very experienced judge who has been brought in by the government to try and oversee some of the problems, or to oversee improvements to some of the legal aid procedures that we have in New Zealand. One of the things that he told us at Select Committee was that related to what's called the preferred lawyer regime that we currently have. That means that currently it's the right of the defendant to choose who should represent them, even if it's being paid for by the Crown. And the bill changes that so that for lower level offences, Category 1 and Category 2 offences, they will be effectively allocated a lawyer in most cases. There is a discretion for the judge to, I think on occasions, override that from memory. Mr Quinn might be able to correct that if I'm wrong on that, but from my memory from Select Committee was that was going to be retained, because there are some occasions where you might have a defendant or an accused who has a history. He or she may have mental illness problems. There can be problems that are known to the prior lawyer that can actually facilitate the conduct of that person's defence and also facilitate the administration of justice generally. So there needs to be some flexibility around that. But nonetheless, we were convinced by what we heard from officials, from submitters and also from Justice Hanson, that by and large the principle that you should allocate these things to the lawyers who are on the legal aid roster rather than let people choose their own lawyers is a good thing. And we heard about cases where the existing rules are effectively being abused by some small minority of lawyers who manage to line up for most of the cases, despite, according to Justice Hanson and some of the other people, actually sometimes being the least competent of counsel. So because they're good at running the relationship with the accused doesn't necessarily make them a good lawyer, even though they're good at convincing their accused client that they're the person for them. So we were convinced at the Justice Electoral Select Committee that was a necessary change. I must admit I was quite shocked to find out how much some people were being paid by the state for provision of legal aid services in relatively minor cases. I think the amounts that were being earned were sometimes more than $250,000 per practitioner. And that's a lot of money, a lot of taxpayer money being spent on a relatively small number of people for the provision of legal aid services. And it did seem that some of the practices that had been identified by Dame Margaret Baisley and referred to by officials and Justice Hanson did need to have some response, and this bill seems to be an appropriate response to that. One of the other areas that we heard was a problem was currently if someone is alleged to be incompetent, then effectively a complaint can be made by or to the Legal Services Board, but then it gets sent to the District Law Society, and the District Law Society doesn't really have control of the funding functions at the legal aid end of the equation, and so there has been a disconnect between the disciplinary processes and what should be funded through legal aid. Now, quite often there could be some sort of poor practice or of the sort that if you were the client or if you were paying the bill, the Crown, you'd want to say, well, we're not going to employ that person again. Well, under existing rules, it was very, very difficult for the Crown to actually stop paying incompetent counsel. And the remedies that were left effectively were a sledgehammer, because you just about had to go to the Law Society and say this person ought to be struck off. And that would have been too great a penalty for the behaviour that was being complained about, whereas it would have been perfectly appropriate for the legal aid people to say, well, we don't want you again. And despite the common sense nature of that proposition, which I think I've just put, the system didn't allow that. Now, this new system will allow a better monitoring of complaints and quality, which will allow controllers to funding through the legal aid system rather than as a disciplinary matter for the Law Society to attend to through their route. Now, in terms of, I should have mentioned something else in terms of the preferred lawyers scheme. We did hear from family court lawyers that it was important that continuity be maintained, particularly in respect of issues like counsel for the child, where there are disputes that relate to children. It is desirable that the same counsel be appointed to represent their interests. And so, at least at the moment, it's provided for that at the family law area, we do have still the choice on the part of the person who needs the lawyer as to who it is that they appoint as their lawyer, even if they're paying that lawyer through legal aid, which is, at least theoretically, a loan rather than a grant, and is meant to be repaid over time, although obviously people who are of the lowest income generally don't end up paying much back. Mr. Speaker, I also agree with the comments made by the Minister in respect of the clarity that has been made to make it clear that legal education is something that can be funded through this new authority. Community law centres were concerned that that was not the case. I think there was also, at the committee though, whilst we agreed with that, we also had a general view that it's important that legal aid services actually don't cross the line from education into political polemic, really. And I have on occasion seen legal aid centres that were set up really to provide legal advice to people for small legal problems primarily that would not be able to access a lawyer. Sometimes they do tend to involve themselves in political causes rather than legal causes, and that's something that I think a line that should not be crossed, and hopefully through this legislation will enable the funders of community law centres to appropriately fund education as well as legal advice services, whilst not crossing that line into effectively funding political campaigns. And I didn't mean political party campaigns, I actually meant campaigns for change, which I don't really think is generally within their purview. Mr. Speaker, another minor change that was made is that the Law Society was concerned that some of the language of the bill implied that some of the work that's conducted by lawyers might be carried out by non-lawyers. That was ambiguous in the legislation, so we tidied that up because court administration and the rights of accused and defendants are best protected by lawyers, and so we wanted to make it clear that we weren't trying to remove that requirement that lawyers be funded. Mr. Speaker, the Regulations Review Committee had some concerns about some of the regulations and the exemptions that were able to be brought about by those who are administering the scheme. We looked at those carefully, and on reflection we thought that the powers that were being conferred were appropriate. Mr. Speaker, we heard from Justice Hanson in respect to this preferred lawyers scheme that he actually thought that we should have a roster for even more serious cases. He thinks that the case for defendants having a choice in respect of Category 3 and 4 criminal offences is not strong, and I think that that's something that we may have to revisit in the future. There was another area which I think has yet to be tidied up, and that's in respect of legal aid on criminal appeals. It used to be the case in New Zealand that the gatekeeper for criminal appeals was effectively the Court of Appeal, and a Privy Council case decided that, or directed that that was inappropriate, that those same judges that would be considering the merits of appeal ought not to have a hand in the decision as to whether the accused was granted legal aid for the appeal, and I can understand the logic behind that. But in my view, someone should be a gatekeeper, and at the moment we've effectively got a position where the state takes it as an obligation upon themselves to fund virtually every appeal on a criminal matter where someone wants to appeal without regards to the merits of the appeal. And whilst I think it's very important that we have access to justice for the accused, and that the accused has the ability to appoint a lawyer, I'm not convinced that that means that the Crown should always have to fund every criminal appeal, even if it's not meritorious. I think that you can actually, if you don't have some sort of scrutiny as to merit, you can end up funding more appeals through a criminal aid system than would happen if you didn't have legal aid.
His time has expired.